Hello and welcome to another episode of SEO Daily. Today we're talking about day 4 of hearings in the challenge to abrogation of Article 370. On Wednesday, that's August 9th, 2023, Senior Advocate Gopal Subramanyam argued that the Constituent Assembly of Jammu and Kashmir was not silent on the fate of Article 370. They expressed their intent for Article 370 to be permanent through the very document that they were constituted to make, which is the Constitution of Jammu and Kashmir. The provisions of the Constitution of India, he said, were not made to apply to Jammu and Kashmir only through a presidential order. Instead, they were embraced by the Jammu and Kashmir Constitution. Subramanyam slowly took the court through the provisions of the Jammu and Kashmir Constitution to prove his point. He argued that the features of the 1954 presidential order, which gave effect to Article 370, was embedded in the Jammu and Kashmir's constitution. He then said that the Jammu and Kashmir Constitution was also deeply intertwined with the Constitution of India. The fact that the Jammu and Kashmir Constitution did not abrogate or allow the Legislative Assembly to abrogate Article 370 was the will of the members of the Constituent Assembly and, by extension, the people of Kashmir put in action. Subramanyam said that the Union of India had accepted this structure and therefore could never abrogate the provision, especially unilaterally. He then asserted that Article 370 of the Constitution recognized a bilateral relationship between India and Jammu and Kashmir. The two entities, that is, the President of India on behalf of India and the Legislative Assembly of Jammu and Kashmir on behalf of Jammu and Kashmir, must work together to make laws for the state. Therefore, any change to Article 370 could not be a unilateral exercise without Jammu and Kashmir's concurrence. It had to be a bilateral exercise with dialogue and deliberation. In contrast to this, Subramanyam said, the 2019 presidential order, that is CO 272, was a unilateral decision of the Union of India without Jammu and Kashmir being considered. In the second half of the day, Chief Justice noted that while the Indian Constitution talks about the Jammu and Kashmir Constituent Assembly, at no point does it mention the Jammu and Kashmir Constitution at all. So, he asked Subramanyam, was it necessary to include parts of the Jammu and Kashmir Constitution into the Indian Constitution to make it an intrinsic part of the Indian framework? Subramanyam replied that the Jammu and Kashmir Constitution was in itself a product envisaged by the Jammu and Kashmir Constituent Assembly, and this body was duly recognized by the Indian Constitution for this sole purpose. He then continued to give more reasons as to why CO 272 was defective. The presidential order amended an interpretation clause of Article 367 so that Constituent Assembly would be read as Legislative Assembly of the state. An incredulous Subramanyam argued that 367 was designed to aid the interpretation and construction of the Constitution. The two assemblies were distinct by nature, and one cannot be forced to mean another by simply interpreting it to be so. CJI Chandrachud pointed out that the main question about the validity of the presidential order hinged on whether a valid state government was consulted before passing the order. Remember, when CO 272 was passed, Jammu and Kashmir was under president's rule and parliament had assumed the power of the state government. In accordance to the constitutional principle of federalism, Subramanyam argued it was necessary that both parts of that federal structure, the state government and the president, must be available to exercise powers under Article 370. When the president's order was passed in 2019, both those parts were assumed by the president himself. Subramanyam asserted that the state government in Article 370 meant democratically elected government accountable to an assembly. So, the usurping of the role of the state government by the parliament was simply unacceptable. Before the day ended, Senior Advocate Zafar Shah, who himself is from Jammu and Kashmir, appeared for the Bar Association of the state. He argued for about 20 minutes, and he's expected to continue his arguments on Thursday, 10th August 2023. There's a more detailed report on seobserver.in, so make sure to check that out. On Twitter, we'll be giving contextualized live updates of the hearings. Come follow us then. Thank you for watching.